the very provisions under Article 19 of the Fundamental Rights of Part 3 we renamed as Fundamental Freedoms and Reasonable Restrictions. As Fundamental Freedoms, Article 19, Clause 1 provides 6 fundamental freedoms such as the freedom regarding speech and expression, freedom to movement, to form associations, and freedom to move to anywhere within the territory of India, and freedom to assemble, and freedom to reside and settle anywhere in India, and the very freedom relating to practice any profession, any occupation, any trade, business, and commerce. As such, 6 fundamental freedoms are provided under Article 19, Clause 1, and the very 7th freedom, that was relating to the freedom to hold, acquire, and disposition of property, that freedom was removed from Article 19, Clause 1 under the 44th Constitutional Amendment Act 1978. So also it was deleted Article 31, which deals with the fundamental right to hold, acquire, and dispose of property. And besides that, these fundamental freedoms itself provided certain reasonable restrictions. So these reasonable restrictions are provided for the public order, public safety, public morality, health, and the very sovereignty and national security, safety. Under these fundamental freedoms are restricted, but these are must be restricted reasonably by the legislature and the executive. And that's why we title it as Fundamental Freedoms and Reasonable Restriction, all the provisions of Article 19. And in relation to Article 19, we'll here discuss one of the first important leading case came over to Supreme Court in 1950, and that is Ramesh Thapar versus State of Madras, and where the Supreme Court expressed that it was the expression of the then Chief Justice of the Supreme Court, Patanjali Shastri, who held that a citizen's freedom of speech and expression could not be restricted for the purpose of public safety and public order unless an attempt was made to undermine the security of the state or overthrow it. No legislation could justifiably be passed to curtail this freedom. In view of this ruling, some high courts took the view that promoting disaffection among classes of or inciting sedition or creating bad feelings towards the government could not be considered as a misuse of freedom of speech, and any restriction imposed by the state to stop this could not be held as reasonable. But since the time changing and the very demand of public safety, public order, morality, the safety and sovereignty integrity of the nation, many legislations were brought to restrict those six freedoms which are provided under Article 19, Clause 1 as fundamental freedoms. And in that connection, we will discuss certain legal ingredients which determine the very conditions of such restrictions and how these legal ingredients determine the very aspects, the scope, and its applicability of these six freedoms as provided under this article. So, the first one that will discuss how it could be and how it is applicable to citizens only, and in that connection, we'll discuss the provision that is decided in the leading case, Alagpuram or Mahantraj versus Tamil Nadu Legislative Assembly, and it was a case of 2016 where Supreme Court expressed that it is well settled that the fundamental rights guaranteed under Article 19 are available only to the citizens of this country, whereas the other fundamental rights under Article 14 and 21 are available to every person who is subject to the laws of the country. The six freedoms enumerated under Article 19 of the Constitution in here in all the citizens by virtue of the citizenship without the need for anything further, and as it was decided in this leading case. And now we'll go to another one, that is how it could be applicable to corporations and how corporations are citizens. So, in this relation, we will discuss one important leading case, and that is Divisional Forest Officer versus Vishwanath Tea Company Limited in 1981 by the Supreme Court. So, in this particular leading case, how it is decided corporations as citizens, the freedoms under Article 19 are limited to citizens, and if literary construct these freedoms would not be available to corporations, because corporations cannot be talked of as having or possessing citizenship, but it has been held that shareholders can challenge the validity of a law on the ground of violation of their fundamental rights, and the company may be joined in such proceeding with proper pleading. So, this was as decided in this important leading case, Divisional Forest Officer versus Vishwanath Tea Company Limited. And now we'll discuss another legal ingredients, and that is relating to burden of proof, and in that connection we'll discuss Another important leading case, Vijay Emmanuel versus State of Kerala in 1986, Supreme Court expressed that the scheme of Article 19, broadly speaking, is that once a law prima facie violates a right guaranteed by any clause of the article, then the state must show how the legislation or order the state action falls within the permissible limits allowed by Clause 2 to Clause 6 of the article and to place proper material to support that argument, as it was decided in this leading case. And now we'll go to another important aspect of Article 19, and that relating those legal ingredients which held that the very demand relating to non-biased attitude of citizens, as it was decided in the leading case, State of Gujarat versus retired Justice R.A. Mehta in 2013, the Supreme Court expressed that it is if a vigilant citizen draws the attention of the state or statutory authority to apprehension of the minority community in that state, then the same would not amount to a biased attitude of such citizen towards the state, as it was decided in this leading case, State of Gujarat versus retired Justice R.A. Mehta in 2013, and in our next legal ingredients, that is relating to state of reasonableness. So, as such, the very test of reasonableness, we found some other important leading cases relating to state of reasonableness, and one of them is the first important leading case, Lakshmi versus State of Uttar Pradesh in 1981. So, regarding the state test of reasonableness, it was expressed that in applying the test of reasonableness, which is the most crucial consideration, the board criterion is whether the law strikes a proper balance between social control on the one hand and the rights of the individual on the other hand. So the court must take into account the following aspects: nature of the right infringed, underlying purpose of the restriction imposed, and the evils had to be remedied by the law, its extent and urgency, how far the restriction is or is not proportionate to the evil, and lastly, prevailing conditions at the time. So, these are the criterions raised by the Supreme Court as guidelines for the government and the legislature before enacting any piece of legislation restricting those freedoms as it was raised in this leading case. So, besides that, we'll discuss another important legal ingredients, and that is relating to the substantive and procedural aspects of those legislations restricting fundamental freedoms as it was raised in the leading case Birendra versus State of Punjab in 1957 by the Supreme Court. So, reasonableness in the context covers substantive reasonableness as well as procedural reasonableness. Thus, in ordinary circumstances, it will be unreasonable to make the exercise of fundamental right depend on the subjective satisfaction of the executive as it was decided in this leading case relating to Birendra versus State of Punjab. And now we'll discuss the very relationship between Article 21 and Article 22 as relating to the provisions of Article 19, Clause 1, and in this regard, we will discuss the most important leading case, Minerva Mills Limited versus Union of India in 1980, and as relating to the very relationship as it was observed, Article 19 is available against state action for protection of freedoms enumerated in this article. Some controversy existed in the past as to whether the operation of this article is ruled out where Article 21 and 22 apply, but the current trend is not to regard those articles as mutually exclusive. Thus, to take one example, a person whose freedom of movement has been taken away by imprisonment or detention does not thereby lose his freedom of expression so long as it is exercised within the valid conditions relating to imprisonment or detention. Here, hence a detainee cannot be prevented from standing outside the jail for publication matters which contains nothing prejudicial to the ground for which he had been detained, as it was decided in this very leading case, Minerva Mills Limited versus Union of India. And now we'll discuss another important aspects of the legal ingredients, and that is reasonable restrictions as it was decided in the leading case State of Gujarat versus Mirzapur, Moti Qureshi, Kesab Jamaat, Kasab Jamaat in 2006 Supreme Court expressed that directive principles are also relevant consideration in deciding reasonableness of restrictions imposed on fundamental rights as it was decided in this important leading case, State of Gujarat versus Mirzapur Moti Qureshi Kasab Jamaat in 2006 by the Supreme Court. So, in our upcoming video, we'll discuss each one freedom, such as freedom of expression, which we will discuss first in our upcoming video. Out of these six fundamental freedoms provided under Article 19, Clause 1,